if you're a homeowner in Arizona and you're going through a divorce, then what happens to your home as part of the divorce is a major issue that's going to have to be dealt with and has a huge impact on your future. So first of all, my name is Robert Larson. I'm an attorney and also the owner of the Larson Law Office in Mesa, Arizona. And this is an issue that comes up a lot. And like a lot of things in the law, there's a simple rule that covers most situations, but then there are exceptions to the rule and sometimes exceptions to the exceptions that can kind of make things complicated sometimes. So first of all, let me just start off with the general rule. So in Arizona, it's a community property state. Community property means everything that you acquire during the time that you're married is considered to be owned 50-50 by both spouses. So it doesn't really matter whose name is on the home. That's true for any other asset. So a lot of times people get hung up on whose name is on the home or on a vehicle, things like that. So generally in Arizona, that doesn't matter. If you acquired the home during the time that you were married, it's going to be community property, it's going to be 50-50. That means it's going to be subject to either be sold, or if someone wants to continue living there, they need to buy out the other person for their share of it. So that's the general rule and what happens most of the time. However, there are exceptions. So for example, if you acquired the home through an inheritance, so let's say a husband received an inheritance from his parents and used that money to buy a home, that could be considered the sole and separate property for that husband. Or if it was a specific gift to one spouse and not the other, that's very rare. You would have to really be specific about making sure that it's not community property, but it can happen. Or if somebody owns separate property. So let's say someone already owns a home somewhere else and they get married, and then they sell the home that they owned before they were ever married, and then they use that money to buy another home. That could be considered the separate property of that spouse too. So there are exceptions to the rule that can kind of make things complicated sometimes. So sometimes people, like I said, get really hung up on the fact that the deed is only in one spouse's name. And like I said, generally that doesn't matter. However, there is an exception to that. And that is where sometimes you have kind of a disclaimer deed that says very specifically that this property is not community property. It is the sole property of one spouse, and it was purchased using the separate property of that spouse. And so there's no claim to community property. So if you have a very specific deed like that, it's possible that the court could look at that and say, yeah, this is not community property. It's this one particular spouse's property. And if so, that can be kind of a harsh situation. So you want to be really careful about signing something like that, especially if it's not true, because a lot of times what I see in this business is a lot of times it's not true, and people sign a deed like that just because for whatever credit reasons, the lender would only give the loan if there's one spouse on it, but the other spouse has bad credit or whatever it is. I see this a lot with VA loans, where the person who was in the military is on the loan, but the other spouse is not. So you want to be really careful if you sign something like that, because that could really cause problems, because courts could look at that and say, yeah, this is the separate property of the husband or the wife, whoever's on that specific type of deed. So a general type of deed isn't going to create that separate property, but if it's very specific, it can be upheld, and a court can say this is the separate property of one spouse and not the other, and that can be really harsh for the other spouse. I've seen that happen, and it's really sometimes very unfair. There's also another exception to that exception, and that is if you can prove that you signed that type of deed under duress, that you were pressured into signing it, and it wasn't really meant to be the separate property of the other spouse. Like I said, for example, maybe you're being told that we can't get the loan and we're not going to have a home unless you sign this deed, or maybe it was misrepresented. And so sometimes you get litigation from people saying, hey, yes, I know I signed this deed, but I didn't do it knowingly and voluntarily. I did it under duress. And in those situations, a judge can say, yeah, this is invalid. It's just going to be regular community property. So it's a fairly simple rule most of the time, but there are situations that can get kind of complicated, just like a lot of things in the law. And so anyway, there are also another situation, I think this would be the topic of another video because it's a completely different topic, but sometimes people own a property before they get married, and then they spend several years contributing payments to the home using community property, and maybe even they make improvements during the marriage using community property. So you have a situation where it's kind of quasi-community property, where like a portion of the home is owned by one spouse as separate property, and another portion is owned by the community as community property. So like I said, that's probably a topic for another video, but this is pretty much just what happens when you're going through a divorce and you own a home in Arizona. It can get complicated sometimes, but most of the time it's fairly simple. So if you like this video, if you found it helpful, make sure to like it below. Make sure to follow so that you get more information. And if you have any questions about anything, about homes during a divorce or any part of divorce process, feel free to give me a call anytime. Thanks.